can Parliament committee meet there? But there's nothing preventing us doing something like that. Huh? Eh? I mean, we just move because I'm saying what is happening now is that there are about 6 joint select committees operating. And the result is not just a matter of personnel, but you can hardly get the room for the time you need. Now, I know there's a shortage of personnel as well because when they overlap, but the space issue could be managed better until you have a parliament with more rooms. It would be feasible to look at taking a room from conference center on a regular basis. Parliament is reserved for like every Wednesday or Thursday for 2 months. No, I mean, ASG. I mean, duplicate ASG and C and the CPC, but some of them have, would be possible. Some things would be possible. But right now we're really running into a roadblock just by the sheer number of meetings with one chamber. A new parliament is a little bit way down the road, even though we're going to get it built. It's a little bit way down the road. By that time, in fact, I expect that both SG and CPC and legal reform will have additional staff. Right? Huh? You'll be retired. Well, when they didn't bring back the retired, but what about it? I think we should have. No one serious. We'll have to have more manpower in the system. That is part of what we have to do. But I think the physical space is now a major restriction as well. Of course, part of your challenge is not just the numbers you have on establishment, but the retaining people you have. If you retain who you have, as they get more experience, you can have a little bit more, you know, more meeting without any challenge. So we'll have to look at that. But I think those are being looked at, and I expect, well, I can't resolve it in 1 year, that in due course they'll be resolved. Right, so today we go back through the entire document, I understand, and then this is a process now we go through today, right? The current document, and then we'll await this resubmission from MNS, an addendum before we finalize everything. Usual tea for me. So where do I start now? Right, the first comment, Mr. We're going to delay this. What does it indicate?
Well, unless you want to say it on record that we're going to.
It's Sunday, yeah.
Because they already did it, so we're going to do.
Mr. Bailey, there's a suggestion here that we should maybe hold your proposed amendments until we do the full JCF Act, which we're not delaying for that long, right? Propose that we look at holding the amendment to the Consular Force Act until we do the full act, which is in process. We hope it don't take too long. I can assure you it don't take too long. I'll get it done. So I'd propose that. All right? So we'll let this hold. You'll not be retired yet. I assure you. We're going to get it going fairly quickly in the new year. So the report is before us. Where's the original document? Thank you for the copy of the original document. The original law. All right, I can go through it anyway. Section 1, no changes. Interpretation. All right. Can we begin the process of the report?
Sorry, Chairman, subject to collective perspective, I'm not sure whether it would be too tedious, but maybe we could actually just read through the report. Yes.
Beginning in.
I volunteer to assist with the reading.
All right. We begin with.
Because there are some things that jump out.
Yeah, when you read it, it comes out easier.
Yeah.
All right. Want to begin with page 7.
So we could begin at the introduction on page 3. Yes.
All right.
The Criminal Justice Suppression of Criminal Organizations Act was enacted effective April 7, 2014. According to the Ministry of National Security, the legislation was developed as a response to the growing presence of criminal organizations or gangs in Jamaica. The relationship between the activities of these groups and the increasing levels of crime and violence throughout the country. The development and adoption of the legislation was, in part, also a response to the 2030 National Security Policy, which identified as a Tier 1 threat the presence of activities carried out by organized criminal groups in Jamaica. The ministry states that prior to the implementation of the legislation, it was a view that existing offenses failed to adequately disrupt the activities of criminal gangs. Criminal organizations inherently act as force multipliers and significantly increased the instances of murder, shootings, assault, property damage, and other serious offenses locally. In an effort to criminalize gang activity, the legislation criminalizes membership to a criminal organization. The commission of offenses on behalf of a criminal organization, the provision of benefit to or gaining benefit from a criminal organization, the recruitment of an adult or child into a criminal organization, and leading, managing, and directing a criminal organization, among other things. Issues analysis.
Before we get to the issues and analysis, my recollection, please correct me if I'm wrong, is that the Act has a provision in it that requires its review within a certain period of time, and that this is actually what we have been doing. And I think it ought to be mentioned in the introduction that this committee has reviewed the Act in accordance with section whatever of the Act.
We're carrying out the statutory requirement.
Yes, yes.
Should be introduced along those lines.
Chairman, Section 21 of the Act provides that the provisions of the Act shall be reviewed by a joint select committee of the Houses of Parliament not later than 3 years after the date of commencement.
Perhaps that section could just be set out as,
yes.
Yeah, in the text.
Yes.
It's very short. It's just,
Agreed.
Yeah.
Yes.
Yeah. It's to introduce in the introduction. So we are carrying out that responsibility.
I'm happy to assist until such time, not for all of it though. Yes. Deficiencies identified in the current legislation. The ministry commissioned a study undertaken by Dr. Joyce Moncrief of the Institute for Applied Social Research and entitled Effects of the Enforcement of the Law Reform, Fraudulent Transactions, Special Provisions Act 2013 and the Criminal Justice Suppression of Criminal Organizations Act 2014 on the murder rate and organized crime in Western Jamaica. The final report of the study was released in February 2017. The ministry advises that the study highlights the results of assessments of the implementation of the Criminal Justice Suppression of Criminal Organizations Act 2014 from the perspective of the Jamaica Constabulary Force, the legislature, and the judiciary. While some of the observations are meant to be specific to Area 1, St. James, Hanover, Westmoreland, and Trelawney, they can be interpreted as reflective of the wider views. The assessment is outlined below. 1. Inherent limitations. The Act does not allow for search and seizure, which has proven to be a critical omission. The Act does not allow for the interception of communication. Courts, prosecutors, and the investigators, police, differ considerably in their interpretation of aspects of the legislation, including what constitutes a criminal organization. Prosecutors are more willing to advance trials for the predicate offenses.
Mr. Chair, just want to make the point that it had been stated in the committee that as regards the first two bullet points, the Act does not create any new police powers in its current form. That was never intended, because the feeling was that the powers of the police are to be found in the Constabulary Force Act and other legislation empowering the police. All this Act was really doing was creating offences and various procedural rules around how those offences are prosecuted. So I think it ought to be reflected in the fact that the Act did not seek to do that, because that was never considered necessary at the time.
I think, Chairman, a valid point. However, this is really just setting out what the findings were. So let's see what happens later on, because if it's not included later on, would be an appropriate place. I'll just complete up to the page 6, and then you can take over the reading.
Chair?
So
before you press on,
Yes.
Chair, if I may, I think the points should also be made in relation to the statement that the Act does not allow for the interception of communication, because this is not something that belongs in this Act at all. And in fact, as was discussed in this committee, the Interception of Communication Act itself is something that can be adjusted by order by the minister to insert whatever offence is necessary. So this is not something that actually belongs to this Act at all.
And in fact, it has just been, hasn't it? I think you've just done
and the
that.
minister has
Arising
done
out
that.
of discussions that came out here early in the day in this committee, you made an order, as I understand it. I don't know where it's gazetted yet or whatever. But that's why I said the first two bullet points, Mr. Bailey. Yeah.
I think, Chairman, things are coming alive in a new way from reading out loud. So the points are to be noted and included at appropriate places if they have been omitted. 2, at the top of page 5, contingent limitations. There is need for an easy and user-friendly framework for plea bargaining arrangement. The best witnesses against gangs tend to be gangsters themselves who participated in criminal activities. It is difficult to secure interim protection accommodation for witnesses in the Witness Protection Program. Residents are fearful of providing evidence, as their immediate and extended families can be targeted in retaliation. Broadly, there is a culture of silence, particularly in communities with high gang density. In addition to the limitations listed in the study, focus group discussions with members of the Jamaica Constabulary Force also highlighted a number of operational challenges facing its anti-gang operations, including less than ideal human resource capacity, inadequate financial resources to enable officers to recruit informants, and the pressure to deliver short-term gains in the face of the complexity of successful anti-gang investigations. Also, further discussions with other stakeholders in the justice sector suggest a divergence of views in relation to the interpretation of certain elements of the legislation among the judiciary, police, and prosecutors. As noted in the study, there is a strongly held view among officials in the justice system that the paucity of evidence presented by the police is a key factor in the low rate of conviction, and also contributes to prosecutors making the decision to go to trial for the predicate offenses rather than offenses under the Act. The gang problem in Jamaica. According to the Jamaica Constabulary Force, the most recent statistics reveal that at the end of 2017, there were approximately 274 gangs in Jamaica. Of this amount, 77 gangs were considered major organized criminal enterprises. In 2017, it was estimated that there were approximately 9,000 members of criminal gangs. In the period since the enactment of the legislation, April 2014 to October 2018, the Jamaica Constabulary Force reports that 448 persons have been arrested and charged for various offenses under the legislation.
Adri, just a quick, before I lose this thought. Minister, near the top of the page, that same page, the second bullet point, just want to note that this is not an area I think that we really went into sufficiently in our deliberations, the question of witness protection. And what we have seen is a major prosecution of a major gang has been discontinued because the main witness has become unavailable. I'm not sure if that witness has been killed or by what means. And the whole question arises, why was that witness not protected adequately as a key witness in a major prosecution of a major gang?
Chairman, I had a similar thought. I was just waiting to get to the end of the section, but it having been raised, the first bullet point, which speaks to the best witnesses against the gang, tend to be gangsters themselves. It is my understanding that in the Dexter Road case, that main witness was himself a former member of the gang. And I see, the highlight of the paucity of evidence presented. And I just wonder, I had wondered whether Section 31D would have been appropriate. But then I also appreciate that where credibility is of critical importance, there would be high demand for the witness to face cross-examination, and it would be difficult for a case to even go beyond the prima facie level in such circumstances. But what concerns me is how it is that the case could turn almost entirely on a single witness. Knowing full well all of this that we know, the absence, the difficulty of securing the witness persons in witness protection, or even if it's available, their own reluctance in many cases, already highlighting the paucity of evidence. And if I'm not mistaken, most of the convictions in the court resulted from guilty pleas. And here we are speaking about, such major success in getting the persons behind the bar. When we look on the arrest rate as opposed to the conviction rate, something is very wrong, very wrong, Chairman. How you can have an entire gang matter turning on a single witness,
and you have
knowing the rules of evidence, knowing the procedure,
and AG,
it collapses.
You have to assume that was the case, that there was really no other evidence, because the DPP's explanation as to why the nolle prosequi was entered is that in the absence of the witness, a 31D application would be destined to fail because the credibility of that witness would have to be tested in court. You couldn't convict effectively on a person's written statement without the possibility of cross-examination of that person. But of course, if there was any other evidence in support of the charges, then maybe 31D would have been permissible because the court could take into account that's the statement. And in doing so, bear in mind that it has not been tested by cross-examination. So the fact that it was withdrawn without even an attempt to test it, and to test whether the court be minded to allow it into evidence, suggests to me that there was really nothing else that they had. So I endorse what the AG is saying about this. I mean, how is it you have such a major case and you really have nothing other than one witness's statement?
I take the concern raised quite serious from a different position of the seat. Of course, some of the limitations faced there are not outlined here because the gangs are part of the community. That's the real challenge of it. There's no gang in Jamaica which is kind of identified, as a separate unit out of the community or organized. They are intimate part of the community. In fact, in most cases, they are the family members see them as benefactors, and getting witnesses out is difficult. Now, infiltrating them makes it very difficult. The other thing we have to do is where we can infiltrate the gangs, and that has proven extremely difficult over the years because they are so close to identify the community. Occasionally, I've had people going in who are from the community and maybe for one event, but it's something that needs to be looked at. In the case of that witness, they would not accept witness protection, and I don't know if we need to look at how we operate the witness protection program to make it more attractive in association with plea bargaining. It may be worthwhile looking at it. It's not something we're going to legislate, I would expect, but some work has to be done in that area because you're just not getting witnesses. And if we were to be brutally frank, that was what led to the kind of extrajudicial activities associated with some of the more allegedly effective police officers out there, because people are just frustrated. The knowledge is available. There's no question about the intelligence and the information, but getting evidence material is almost impossible. And we have to look at how we can make whether amendments to some of the protection program or other activities in terms of securing witnesses that can begin to allow investigators to get the kind of evidence they want.
What aggravates my concern is the fact that the final report of this study, which was commissioned by the Ministry of National Security, became available from 2017. And these issues were brought to the fore ahead of this review of the law. And I just wonder what process is there internally when reports are commissioned to look critically at the findings. Because we have a time gap between that knowledge, and as you have pointed out, there is a certain reality to the gang culture. But context is context, and you can't wish away the current context in which you have to investigate any alleged offense. And if it is known that victims and witnesses are also part of the criminal enterprise, then how else is investigation being pursued in that context? Because if we're going to hear the high number of gangs, and in an area where many are said to operate, and the major gang operating, you have intelligence, can't mount a successful prosecution.
It's expensive and has gone through the procurement process, which took a long time. Plus, there's personnel in the police force itself, where there has to be increased screening to ensure the professional caliber of the individuals, screening and training operational there. And certainly CTAC had some amendments done to it, but there's more to be done. And I think those are areas we have to look to bring improved investigative capacity. But the reality of what we face is that the investigative capacity of the force, I made a comment at the beginning, was significantly depleted to redirect the force to operational activity, coming from a number of years back. And you end up with the kind of activity I alluded to that was not in the best interest of the community or in keeping with justice and prosecution and proper justice system. We have gone through a lot of things to correct that, but we did nothing in the force, that's quite frankly. Work is going on now to improve that section, but we'll also have to look at how we can improve the specific area of witness protection. And see, it goes together. If
you have to prioritize it, because if gangs are responsible for the bulk of the murders, and dismantling the gang is a tier 1 response to a tier 1 threat, then in allocating resources within the witness protection program, one has to be very strategic in how that's done. I mean, if you have a major gang, you have a pending prosecution, men in custody, and you have a key witness, that person has to be protected to see that. That trial must be expedited, and that person must be protected till the trial is complete.
In this case, the person refused protection. Now, I wasn't aware of that before, because we could have taken greater action.
The Deputy Director of Public Prosecutions is here, and I believe may contribute to the discussion.
But the person did in fact, I'm told at this stage that they refused protection, and they had been advised that some work was done on the scientific side, but of course, that appeared not to have been enough to carry the case, and I'm hoping as we proceed that will improve. Well, it should improve as we complete the development of both the entire Forensic Institute, including the Forensic Ballistic Institute, and along with the other activities surrounding forensics.
If I may, Mr. Chairman, cases like the Dexter Street gang, I don't want the impression to be given that both the police and the DPP were tilting at windmills, in that the case rested entirely on one witness. Pardon me? the way how the case was investigated, the Dexter Street gang actually is a series of offences that took place in Westmoreland over a period of years. What happened is that you had a collection of cold cases in the Westmoreland police. You had these incidents in which nobody identified who the perpetrators were. The forensic evidence, if there was any, was negligible. The only person who connected the persons to these incidents was the one witness, who was a former member of the gang. And if I recall my little reading of this file, had lost every family member to that gang, which is what motivated him to come forward to testify. So it's not ideal in that we don't have other aspects of evidence, but in every criminal case, we don't have forensic evidence just jumping out of the window to come and present itself. In many gang cases, because Dexter Street is one such, Chance Wilson is another one, in which there's a series of incidents over 7 parishes in which nobody could identify who these persons were until we got these 2 witnesses. And in fact, our entire case is based on what these 2 witnesses say, because they were former members of the gang and they are able to identify these persons. It is not ideal. But the way how many of these gang cases are, they start cold, and it is until they provide the requisite information that you can actually build the case and get the evidence. So it really and truly was not a fool's errand. Perhaps you may have to look at how witness protection is organized in this country. Because as it is at present, it is only law-abiding people that the witness protection will take on. If you have a charge or if you're suspected of being charged, witness protection is not eager to take you on. In many cases, the police have had to find their own solutions, police to police, either here and abroad, in terms of protecting the witnesses outside of the formal witness protection system. So perhaps this is an area which we'll have to look at. And also in relation to as other gang cases come up, and as we are discovering, persons who may be in custody, how do we protect them after they give their evidence? We send them back to prison for the revenge to be exacted upon them, or do we now have to have special areas to hold them if they are in custody, or for them to serve their sentences after? So these are all the things that are presenting themselves to us who are the ones prosecuting and investigating these cases.
Minister, this is fundamental to this legislation being able to work.
And with you, Mark, because I'm allowing the discussion, because I think there's some kind of rooting out of this.
It is very, very critical. Both points that Mr. Palmer made. It's clear that the system of witness protection was not designed with anti-gang and inside gang members as the main witnesses in mind, but that is internationally known as the main way in which you are able to tackle prosecution of gangs, is through persons inside deciding to give evidence. And that is why we need to address this so fundamentally. And then the point about what happens after they're released from custody, when they're no longer witnesses, perhaps, because the case may be over, but they may be at risk. And how do you assure them of ongoing protection at that? These things need to be dealt with. Otherwise, we're not going to be able to successfully prosecute these gangs.
Chairman, thank you, Mr. Taylor, not Palmer, for the update. Perhaps we need to add something a little bit in relation to this discussion. But what jumped out at me from what Mr. Taylor said is that the program as currently, the witness protection program, does not allow for criminal participants to be protected. But if his primary role is that of witness, regardless of his antecedents, then I would like to think that there must properly be a place. And so, Minister Chairman, This is something that I would commend that you take back internally to the ministry which has responsibility for this area, this subject matter, to look at most urgently. The design of the witness protection program and the current limitations in relation to witnesses who are criminal participants. Yes.
Take it very strongly, agent advice, because I'm aware from in another situation that one of the challenges that many of these youngsters who turn in the community often feel that they are strong enough to protect themselves. They feel they're at a point where they don't feel they need to go into protection, and they have built their own reputation, and oftentimes have renewed their own little team around themselves, and that creates a big problem. So we'll have to look at it carefully. I'll in fact, well, hopefully by the final sitting of this committee, give you some idea, although it's not part of the legislation. If there are, of course, any legislative area that can be helpful, certainly the plea bargaining, I don't know if that will come into it and how we structure plea bargaining.
Well, we've just done an overhaul of the plea bargaining legislation.
Right.
We have a brand new plea bargaining statute. I don't know how well it's working or not. And apart from that, there was something else that was done when I was minister, which basically facilitated guilty pleas through giving heavier discounts on sentencing. I know that has had some traction in that it is being used, but the plea bargaining, the more formal plea bargaining process, I don't know how it's working or not working. We haven't really had any data on that. Yeah.
AG.
Chairman, may I just ask that the recommendation that the design of the witness protection program be re-examined with a view to considering the inclusion of former gang members in particular, but persons who would have participated in criminal offense, be one of the recommendations of the committee, and that it be included at the appropriate section of the report.
And also that it be expanded to accommodate their needs for security after they have completed their period in custody.
The custody station is one is critical because there may be less secure in custody than on the street, knowing how the prisons operate. We are making some change there as well to do that. And I said, certainly, I want to reassure the committee that I know that the work on the scientific side, in terms of the development of the Institute of Forensic Lab, is proceeding and could have a marked effect. Things like developing a full forensic ballistic section, which will then, and they provide kind of data and information that can work with both the investigators and the prosecutors to build out a case in addition to what is required by the eyewitnesses. That work is ongoing. It has come a long way, and we expect to really complete that process during the course of this year, but it's far more intense and expensive than I thought of, but it's coming on very nicely. I want to assure the committee members, and will in fact give you even a formal report.
Chairman, two further thoughts before we proceed. Following up on what Member Golding had said in respect of the identification of the gang problem as a tier 1 threat, I do recall that in the 1990s, when the drug running was regarded as the tier one threat, there was a special team in the Jamaica Constabulary Force that was set up to deal with that. I don't recall hearing outside of MOCA, or I don't recall the appropriate connection being made for a special unit to target the gangs. If it does exist, pardon my ignorance. CTOC is what it is.
Designed primarily. It is counter-terrorism, but they're not as the Jamaicans say, knock wood, we don't have a big terrorist threat. Yeah, we have a gang threat, which is where they focus their attention on.
So again, Chairman, it may be a matter of realigning, because, and I don't know, did CTOC make a presentation here? So again, if it is that I understand, but the subunit, because I believe we've had a fairly robust discussion and review so far, and as we're coming to tie together and looking at how we're going to make the any amendment effective, to the extent that there is a special unit, it would have been and it would be useful to hear what the operational experience has been.
That could be useful for your comment. The CTOC is a specific unit with a grouping there, but with the emergence, the real challenge is to ensure that the intelligence and the investigating, prosecuting team interact smoothly. And I say at this point, that is where we have to, that's what we have to settle, and it's not easy to settle it quite yet. A lot of progress has been made, and I expect as we go forward, you'll see the evidence of it. But we have to get all the intelligence units, all of them, to coordinate and feed in to a unit that we think can convert that information to evidence. That link, that pipeline from the intelligence to the units involved, operational units, it has not yet been settled in the way that I'd like. It is a little bit more than just meeting and coordinating. And CTOC itself is undergoing some current changes, so I think certainly you could get an information on the operational challenges, but that's one of the areas of the police development that is being worked on. And as I said, in the latter case, I'd expect some more progress. Both the Uchensville and the Dexter Street were early cases in which increased cooperation with the prosecutors and investigators took place, but there's still a way to go and to ensure that the quality of the evidence, especially scientific evidence, is improved.
Chairman.
Just to say, for the benefit of the members, we are visiting with us this morning members of the Lorna Otter Prep School from Linstead. We want to welcome them to the sitting. This is a committee sitting. We are looking at a particular piece of legislation called it's anti-gang legislation, but the actual title is the Criminal Suppression. Criminal Justice. Suppression of Criminal Organization Act. They're the young ones, but we hope you learn from it. It's good to see you here. You are not allowed to speak or give any gestures up there, but we hope you learn something from the deliberations down here. The topic is, of course, a very critical one, which is to deal with gangs which are disrupting communities. Your teacher can explain a little bit more to you. The Criminal Justice Suppression of Criminal Organization Act 2014, we are currently reviewing. All right, thank you. Welcome, Madam AG. I know you like to see the young ones.
It's just that this is such a heavy subject area that I'm not sure it's the matter that the children would find most exciting, and I hope it doesn't scare them, but such is the nature of the work of the Parliament.
And for their interest, the members on this side are sitting members of Parliament, Senate and House. The Attorney General is speaking, Senator Karen Morris from St. Catherine, and MP Golding from St. Andrew, myself from St. James. And on this side, the big team are the people who do all the work that we come and talk about.
The real experts.
The real experts and individuals who do the work that allows government to function. They come from Office of the Parliamentary Council, who writes the legislation, the Attorney General's office, that really keeps us on the right path, legal reform, who helps to write and advise and pretty much everything in law, and of ministry staff and the DPP's office. That's the Department of Public Prosecution. So the lawyers who are carrying out the prosecutor work. And of course, the Ministry of National Security staff are the people who do a lot of backroom work, but you know less of them. But all spaces where you can make a significant contribution as you assume your own professional standing in the field of law in particular and policy.
Thank you, Chairman. I think Member Carencia had a question.
Chair, I signaled this question to my colleagues here, and they said that I should put it forward. Where a witness is so critical to a case, should that witness be able to determine whether or not he or she wants to be protected? Because in my mind, how I am seeing it, if you are so important to this case, so the state really needs you. Can you now up and decide that, hey, I want to go along merrily? Or should we find a way, it's not to arrest, but somehow to impose
a critical
something?
point, you're talking about preventive detention, you know. I mean, I don't know what law, but you're talking about preventive detention.
I mean, is there any precedent in any other jurisdiction for which has had or has high problems of violent crime and organized criminal networks, where witnesses are not permitted just to opt out of a protection program, but maybe compelled to join it. Does that exist anywhere? I don't know.
The rules of competence and compellability would apply because they are not excluded. So yes, you could find in-law justification to keep, but it would have other consequences.
We have come to a point, and as I said, I've allowed discussion because it's crucial to what we're dealing with. Because what we're seeking to do is what we have established by our constitution and our practices, that we need the best route to disrupt the gang is to arrest them, prosecute them, and lock them away. The fact is, if we have hurdles in meeting that standard, we have a challenge, and we need to overcome those hurdles, because certainly the allegations of extrajudicial activity have damaged us for a long time, and it did not do anything without any question. I mean, homicide rates just keep going up. But my concern, if we, at the rate we're going, unless we can find a legitimate, legal, constitutional, correct solution, we face real problems. Only recently, I think is last week, we saw what happened in another jurisdiction near to us. The gangsters chased the police off the street and released the gangsters that were detained, literally, in Mexico. And in the end, so the police officers were hobnobbing with the gangsters because they just had to move out. They had increased firepower, or better firepower, better numbers, and certainly appearing at the station, more military resources. The reality is that if we don't deal with it, we'll end up with blocks of our community which are currently challenged, becoming totally extraterritorial. And the question is, do we have adequate legislation to deal with it? And if so, what more do we need, quite frankly?
Without descending too deeply into criminal law theory, might I just ask that as part of the recommendation to have a fresh look at the design of the witness protection program, that perhaps law reform could assist us by looking at how, if at all, the rules relating to compellability of witnesses could be modified to address any gaps and concern there. And just to tie this back to the distinction between criminal law and civil law. So when a crime is alleged to have been committed, it's a crime against all of society. And that is why it is brought in the name of the head of the state. And there is significance to that. That is why time never runs against the crown, except where the offense is a statutorily created one and the statute prescribes a limitation. There are a number of things that we perhaps will have to go back to basics to understand, because this level of deep rootedness of criminality in Jamaica cannot be addressed in a superficial way. It's so ingrained. The tentacles go so deep that we have to go back to the wisdom of founding times, because it's almost cyclical. The last point I want to make, Chairman, before we continue the review of the report, is something jumped out at me.
Thought, AG, what you just said, make a point I think we need to absorb. It's cyclical, and what you get is gangs, and the second phase is always worse than the first phase. Gangs are community-based, and they not only kill and increase killing exponentially, but they grow exponentially. So one dies and the two brothers pick up because he was killed by another gang member. So the gang that comes in another in 1 year's time is double the size of the first one, because every brother, sister, every brother, uncle, and cousin get involved, and they expand. And this, the comment that on the SOE people sweep the community and pick up young men is a ridiculous comment. I mean, I represent the community. Gangs are normal part of every community that have challenges. They're just the same young men you see sitting on the corner. It's the same one involved. I mean, I've been told, I go into a community, I have a really good relationship with all my constituents, and a young man will tell me, those guys walk with you, Doc. They are the good guys. We know what we're doing. You're all right. Do your thing. You're all right. And they just sit there. They're just normal in the community. This is not your business, that is your business. And if what we have the opportunity, we can divert these young men, and that program has to proceed. But at the same time, when people are killing each other, we need to find the killers arrest them and charge them and lock them away. And they are not distant from us. We behave like, well, I don't know. It is.
No, Chairman, you and I are almost neighbors in the representation that we bring to this House. And there is a certain reality which you have been pointing out, which is a lived experience, which perhaps is not sufficiently understood by the wider society, who make a hue and cry when police operations occur. And not that there isn't validity to their hue and cry, because we have had such a painful past of excesses in the use of policing powers. But where an entire community is embedded in a certain lifestyle, and as you say, almost all of the community is part of the group. And if you go in your attempt to address it, naturally it's going to be taking up a huge part of the community. And others looking on are questioning, the innocence of persons without understanding and appreciating. But I think our work is cut out for us because there is such a credibility gap when the political voice steps in to deal with issues because of all of the traditional concerns that have been raised between gangs and criminal elements and representation and all of that. But not to lose focus, Chairman, in the second paragraph where the report noted the pressure to deliver short-term gains in the face of the complexity of successful anti-gang investigation. In the criminal justice research community, when an issue like this is raised, it is something that is to be brought to the surface, because where I don't know what kind of pressure is being hinted at for short-term gains, but the research world has identified the pressure to arrest someone when a heinous crime is committed. And in the face of that pressure, without the thorough investigation being done, people may be taken in. So I find it a little curious. Pressure to deliver short-term gains, don't know what exactly that is referring to. And then the complexity of successful anti-gang investigation. The two seem in contradiction to me, because I don't know exactly what it is speaking to, but it's something critical to find out and probe a little more.
Certainly, and without taking this discussion much longer, but the complexity is well established. It takes time, and you have to have to find a trusted team of police officers, and you have to establish that, a professional team who can apply themselves over time, because given the structure of the gang, it takes both the technology and the personnel to get out there and link the information and intelligence to the evidence required and build it out. Certainly, I said we are taking steps to improve the capacity of the police force in that manner. But it takes longer than people would expect. Not only to train a good CIB man, retain them because people are leaving the force. And some retention have improved, and then provide them with the requisite support, which is not easy. And some of them begin to intercept, begin to bother and question how you handle it constitutionally. Because while you can get the intelligence section of it, to move into evidence requires another type of activity. So that makes it far more complex, and there's pressure to have quick impact. It's a public issue. I've said elsewhere, the public condemns extrajudicial killing, but what they look towards is still a quick response. And when I'm in Parliament, there's a particular policeman who's the most popular policeman in the country, whose feature activity is unacceptable, but that's what he has been made. He's become a hero of the people because he will get out there and get something done overnight, which is not necessarily legitimate. And that's the kind of complexity. And the way I've seen it, quite frankly, is, and I may be wrong, I don't want to analyze things from my perspective, but you term heinous and high-profile crime. There is, I think the society have established what I call legitimate and moral standards based on, correctly so, the middle class of the country. That's how societies operate. But they don't seek to apply the same standards to our the low socioeconomic grouping. So the killings taking place in our inner city don't evoke the same emotion that takes place outside of it. And that bothers me quite considerably. That is just the reality of it. I've said that I put on record when my friend didn't know it was the mother of a mother who was being charitable. She went to help somebody in the kitchen to prepare lunch for people who needed lunch, and the gentleman himself was just happened to him in the different community. They killed him within the eyesight of the police, the soldiers, because there was a crowd there and they just walk behind the crowd, shoot them, walk away. Nobody, it never made the news. It was just, hey, killing taking place and so not working.
Many killings don't make the news.
It didn't impress anybody. To me, it was far more painful because the lady was my friend. Now, my other friend died. He's a businessman. And a far more, I'd say, a criminally accommodated circumstance because they went to his house 2 o'clock in the morning when everybody is sleeping. This was my first killing happened the day at 10 o'clock in the morning. I was about half a mile away. And this one happened at night. They invaded his house, take him over, carry him to his business place 4 o'clock in the morning and killed him. But the whole society raised because the businessman had been killed. No, he was my close friend as well. And that reflects the dichotomy in the society, which is one of the challenges we face because this society, I am not sure is prepared to do what is required to overcome criminal organization.
Minister, Jamaican society is like the frog in a pot on a stove. And as the water was nice and room temperature originally, and as it got hotter and hotter, it's like we don't even notice that we're actually in boiling water. And some of our attitudes towards what's going on around us and how we prioritize measures versus other considerations to addressing these things, I think is reflective of the fact that we are sort of become numbed to the very stark situation in which we live. And of course, it's exacerbated by the dichotomy you mentioned between the realities of those who have means and means of protecting themselves and most of our citizens who are completely exposed to this thing. Yeah.
I'll say to note the AG's advice to look again at the plea bargaining, at the witness protection program, to what extent we can take steps to make it more effective, including anything that can be brought in regulation or legislation that could be of help. And it won't be here, but I'll certainly, after the discussion, look again at what we're doing to improve the capacity of the police in investigation. And it's not a matter that comes to this committee, but I'll certainly follow it up. We have been doing it, but I want to see that it's being done as quickly as possible. It's expensive too, and it's a question, I said, whether the society is willing to make the commitment to the cost and the time. This culture has evolved over the last, I'd say, 40 years in particular, of our 57 years independence. If you look at the statistics, although we had a uptick in the 1980 election, that was something we as the have to take responsibility for. But after that, it started at the end of the 80s, it just started going up. And I never looked back since then. So you're looking at roughly 40 years of increasing gang activity, which is not going to be overcome in 1 year. I certainly have to hope to have a bigger impact in a short time, but it's going to take time to eliminate, to really disrupt the whole system and change the whole culture. And we have taken some action within the institutions, but there's much more to be done, and society have to be, accept that there's a lot to be done.
And then Member Golden can pick up after that. So, still on page 5, the police divisions that recorded the highest number of arrests were St. Andrew North with 67, Kingston Western 52, St. Catherine North 27, St. Andrew South 25, St. James 25, Clarendon and Kingston Central 24. Of the police divisions listed above, St. James recorded 341 murders, Clarendon 167, St. Andrew South 151. These account for the top 3 divisions for murders in the period January 1, 2017 to December 31st, 2017. Despite the large number of arrests, the number of convictions is extremely low, with only 2 convictions or a 0.44% rate being recorded for anti-gang matters over the period April 2014 to October 2018. The first conviction recorded was of Jordan Markland in January 2017, with the second conviction occurring in April 2017 when career criminal Aston Daly, OC Daly Boy, was convicted for participating in a criminal organization. Both men were members of well-established criminal gangs that operate in the St. Andrew North divisions, the One Ord and Klangsman gangs, respectively. If I'm not mistaken, these came by way of plea of guilty. Can we get a clarification? Yes? So perhaps the record should show that, because it's of significance. The Jamaica Constabulary Force suggests that criminal gangs are engaged in numerous acts of criminality, including contract killings, drug trafficking, lottery scamming, firearm trafficking, and extortion. In 2017, it was estimated that criminal gangs were responsible for 985 of the 1,616 murders recorded for that calendar year.
Sorry, JG, also, when you talk about conviction rate of 0.441%, that's very misleading.
Yes.
How many matters have actually gone to trial? I mean, you can't talk about conviction rate on cases that haven't even been tried. So I think,
We should get the information, but I think what they're referring to is, as I said, not many have gone as gang under the Anti-Gang Act. Many of the people arrested were charged under predicate offences, and we should maybe get that separated out in that context. And because when it's reviewed,
this is the kind of data that the media will pick up on and confuse the public completely.
I'd urge my staff to maybe get some of this data for discussion here, because before I take Mr. DPP, I think when we decided this review, part of the challenge we're having is that there are very few cases that are being brought. I think since CTAC has gotten involved, there has been a much closer collaboration with the DPP's office, and a number of cases are being brought, but they are still early days, and that's why I said the capacity of the police has to be expanded in terms of their capacity to convert information and intelligence to evidence. The culture was not just not, we have to just face reality. That quite frankly, I say it here, and I hope I am not stepping onto in the con. The reality of extradition killing Jamaica came out of this particular culture that everybody is known, but there was no evidence to take the body anywhere. Now that we are reversing that culture, we have to be committed to investing into the police force in both human and physical resources to give them the capacity. Otherwise, this thing is just going to continue, because right now, until they get increased, what you're having is that the reality is we dealt with all the, what you might call the requirements to prevent, to control extrajudicial killing. If I might put it bluntly, we took steps to control extrajudicial activity. We did very little to give the police the capacity to go judicial. And I repeat that is a fact of what we do. We put in the common number of legislation that today many of the strong policemen refuse to get into a station where they take on any of the big criminals. And while more work is being done with the introduction of MOCA and other intelligence agencies to get to the white-collar leadership, which is emerging, the guy on the street is still the man who caused the killing. And you don't have a young officer who just come out of police school to go and take on a man who have an assault rifle who has been working for the last 5 years and may have killed 20, 30 people. If not, you'd be responsible. The men who know how to do that are just not in a position to do it now, because it destroys your career. And we have to look at that aspect of it, because we, as I said, we strengthen the civil laws, which are important in reducing that kind of activity, but we did nothing to improve the capacity of the police force to do what is required to take them to court. We are doing some work now, and it will take time to bear fruit. Sorry, DPP.
If I may, Mr. Chairman, just to address this issue of the 2 convictions. When the Act was passed in 2014, and my memory of this is clear, I remember one particular police division in central Jamaica started to charge 3 or more persons with every offense with participating in a criminal organization. And most of these offenses ended up in the gun court. And it is there the prosecutors made a decision whether we will continue with the participate in the criminal organization or just strictly go with the illegal possession of firearms, shooting with intent or wounding with intent. It's not until these 2 cases came in which a pure gang offense was brought before the courts. That is, offenses which arose purely from the Criminal Justice Suppression of Criminal Organizations Act without any predicate offenses attached. So these were the first 2. I don't know if you notice that there are 2 individuals, 2 single people who pleaded guilty. Once you start taking them up in numbers, they draw strength from numbers and decide to hold out and plead not guilty. The second thing is, those 2 cases provided a template as to how these cases were to be investigated. There were some improvements that have been made on it, but they provided a template. So you will notice that from 2017 coming forward now, you're seeing more cases brought as purely gang cases and the absence of predicate offenses in that respect. So they provided a template. I know that there's a tendency in the way how it seems that this consultant report is going to knock the lack of convictions, but I think the police ought to have been commended that they investigated a case and it was so tight that these 2 persons had no other option but to plead guilty, which included also videotaping of their confessions. But I say that for what it is worth.
Well, as I said, no, fine. What it tells you, DPP, is that this kind of matters, it not only takes time to prosecute, but the entire team have to acquire the experience to do it properly. Then you will have a piece of legislation attacking a very complex and difficult problem. It's not going to be done overnight. So it takes time for the police to acquire the experience, required to provide them with requisite tools to do the job, and then it takes time to build out evidence with the prosecuting team to approach the prosecution correctly. So a template is being established. I'm hoping that I expect that with the amendments to the law, which we are now doing, and the increased experience out there and the increased capacity they have, when we finish this, we'll have a stronger template on which to operate.
And Mr. Chairman, the truth be told, a good gang case takes a long period of time to investigate. Because especially when you're using accomplice evidence, you have to have corroboration of some form. Ideally, we perhaps would prefer a case that's been investigated for maybe 1 to 2 to 3 years before we bring it to trial. I know the situation which police officers work under, that after a while, when a case begins to stretch out too long, you wonder why the people are still on the road and no arrests are not being made or so on. But an ideal gang case takes a long time to investigate, where you try to close all the loopholes. So when we bring it to trial, we can have it beyond a reasonable doubt.
Thank you, sir.
Chairman, again, in what the senior deputy has said, there is so much that we need to bring the public into, because if it is that persons are under investigation as part of an organization and it is taking time, the related question is, before you charge, if someone is a real suspect, how do you treat with that person between the stage of suspecting them and charging them? And what are the options open or should be open to the state to deal with that interregnum? And also whether between charge and the commencement of trial, again given the complexity and the number of persons, whether special rules should apply, a different rule should apply, as opposed to when you're dealing with a single accused. These are all related questions which must be looked at as we examine the overall effectiveness of how we treat with it. I don't know if two things have really sunken in. the reality of the culture and the extent of community involvement, which means both victims and potential witnesses are part of that culture, and just the sheer time it takes when the criminal network has been operating over time to piece things together. And how should the system, the justice system, formally respond to that in the light of so many concerns about liberties? This is going to be the crux of the matter for us.
AG, as we know, comes to the conclusion of this section, but I think while it's not legislative, I think from where I sit, more has to be done by myself as the minister responsible in another way to bring the public on an informed basis on what is happening, because I think some of the lack of support, I think, in time is just a lack of understanding. And then whether it is a parliamentary statement or otherwise, we'll have to find a way to engage the public in what, not only we're doing, but the challenges we face, because the gang and their activities is the single largest security threat to the country and the public safety in this country. And it is not just the largest in the proportion that it is. We have a peaceful society and gang thing is the big one. It is a huge threat to public safety.
Not involving the alleged gangs of Gordon House in that.
Maybe they too. Right? So I think I have to examine how we keep the public informed, both on what we're doing and in terms of the challenge we face here, because I think, as I said, the dichotomy in a society, what is essentially a social dichotomy, means that what goes in public opinion oftentimes is what suits one side of it, except unless there is some major horrible activity that impacts on the entire society.
To go back to the point of departure, I think Member Golding was seeking clarity on what the 0.44% actually represented. I'm not sure if the information provided by Mr. Taylor answered it. I heard you say that charges were disaggregated, as it were. The proliferation of charges without there being evidence to ground them under the anti-gang law. You went for the other offenses, and then the actual cases where you could get a conviction under the anti-gang, those were separated out. So, but usually when you're measuring conviction rate, it would be the number of cases brought to trial and concluded, not just those that are charged and hanging out. So we just wanted some clarification for accuracy on that.
Yeah, I did say before that I'm going to invite the ministry staff to get some empirical data on this, because Mr. Taylor was really giving the general principle. Because they say 0.4% is after maybe just near half, maybe 5 cases were taken to court out of the 485 arrests. But the actual data, I'll invite the ministry staff to get empirical data we can discuss.
And you know, Chairman, the report, I don't know if it's the same report that that is referred to at the beginning of Section 3, which was the one released in February 2017. But at that date, the legislation was barely it was probably less than 3 years old. So any charges brought under that legislation, given how long it takes matters to come to trial in Jamaica, and especially complex matters, you know, one wouldn't expect to have seen a whole plethora of trials and convictions by that stage. So the data around, you know, as a conviction rate is really, that data is not helpful.
It's early days, and as we also indicated earlier in discussion in the committee today, we have discussed the need for us when we pass original legislation, especially those affecting the police and other law enforcement agencies, to do sensitization among everybody who is involved until the kind of experience is gained from prosecuting cases, which there can be the alternative to develop the expertise required is to get involved, work as hard as they can, and take them to court and learn from that. It will take a little time to get where we want to go. Thank you.
So, Chairman, picking up, the Jamaica Constabulary Force suggests that criminal gangs are engaged in numerous acts of criminality, including contract killing, drug trafficking, lottery scamming, firearm trafficking, and extortion. In 2017, it was estimated that criminal gangs were responsible for 985 of the 1616 murders recorded for that calendar year. At the end of 2017, the top 4 criminal gangs operating in the island were Klansman Gang, St. Catherine North, Tivoli Young Generation Gang in West Kingston, Denham Town Group, Kingston West, and the Taliban Gang in Kingston Central. It should be noted that the 2 West Kingston gangs were formed out of the remnants of the presidential clique, previously led by Christopher Dudus Coke, which was dismantled in the May 2010 operations in Tivoli Gardens. We note the increased reliance on the legislation based on reports of groups of individuals being arrested and charged under the Act, and the Act has been mainstreamed as one of the tools in the strategy of the security forces. The reports include that up to 24 alleged gang members were arrested, and these are said to be responsible for the commission of serious crimes, including murder, shooting, extortion, and being part of a criminal organization. One current case is the Usain Wilson, which is not yet complete. We know that the issues being experienced include the low conviction rate, with only 2 convictions since the enactment of the Act, despite the 448 persons arrested and charged for various breaches of the Act. The 2 convictions were a result of guilty plea. I'm not sure why this is in red, just to be clarified. But Chairman, I'm a little puzzled that what we are recording here in respect of the top 4 criminal gangs, and how many of these are before the court? And how does the Usain Wilson gang relate to a categorization by the constabulary force that these are the top 4 major gangs? Just a little curious, because you would hope that, well, let me just ask and leave it there, and then Member Golden can pick up the reading.
Yeah. I would just ask, when we're talking about 448 persons arrested and charged for breach of that, how many of those matters have come to trial? That is, I think before we start more convictions, have these matters actually reached trial or not? And, that I think is a more relevant data. So,
We'll certainly get you the data. I don't think many have come to trial. In fact, I think except the 2 mentioned,
the guilty pleas,
Taylor may comment.
Yeah.
I think on the Usain Wilson gang is currently on trial.
Yeah.
The other people are awaiting trial.
Correct.
But they are detained for that purposes.
So useful data would be how many are awaiting trial.
Eh?
It would be useful to know how many are awaiting trial.
With the 19 gone, but still a fair number.
Yeah.
The other thing you need to, in terms of classification, that too I can get data on for you. My most recent data is there are 381 gangs. The number of the number who are considered high risk or heavily active are still about 70 plus, but there are now 381 identified gangs across the island. So the numbers are not much more than 9,000 still. In addition, these that are identified, I think, has to do with the number of homicides and their level of extortion and the economic activity that they're involved in. So they're identified at the top. But again, this is based on an intelligence qualification as opposed to identifying their criminal activity, getting the evidence to charge them and bring them to court. So that is something that could be of value for the committee.
Chairman, I share the view in part of Member Golding that the conviction rate of and by itself may not be as useful, but it is important that it be included. But I would ask for
not
something
as a rate,
further.
I think it's misleading to include it as a rate. I think it should be included in terms of the number of convictions, the number of trials, the number of arrests.
Statistics, as early days, so we had reviewing it at 3 years, and 2017 was like about not yet quite 3 years. But what I would undertake get for you is a full batch of statistics, which I know both of you have been asked for some time.
Let me just clarify why I say I only share it in part. Because what we're doing here is assessing the effectiveness of the law between passage and now, and to see how we can improve on it. We must know of the number of cases tried and concluded, how many resulted in a conviction, whether by way of, including by way of plea or trial, and how many ended by way of acquittal. And I think we needed to be further disaggregated. Was there any matter where no further evidence was offered?
Acquittal
was there any no case submission? We need some disaggregating of the data. No case submission upheld, no further evidence offered, nolle prosequi entered, whatever. And the nolle pros is not a disposal on the merits, because the case can be brought back. That if it is intended to be a disposal on the merits, then something else would have to follow. But Chairman, in respect of the listed 448 persons arrested and charged, we must have the data. How many of these cases are complete and set for trial? How many are on the mention list, and what are they being mentioned for? Is the case file incomplete, and if so, what remains outstanding on it? Are you awaiting settlement of legal representation? We need to find out exactly what is happening. Any of the many issues. Are the witnesses unavailable? Are there issues with the police witnesses as opposed to the civilian witnesses? You have forensic evidence, if applicable in the case, outstanding. Whatever it is, the data needs to be disaggregated. How many are before the circuit court, if any before the parish court? And in respect of the decisions taken, it may be helpful for us to find out in the first dispensation of cases being brought before the court, how many the assessment was taken to go with the predicate offenses. Because unless we get the real data, we may not be able to make the kind of decisions that are required to bring effectiveness to this area of the law.
AG, and we'll move from there. And I think some of this ought to have come at the very beginning, but I think we went through quite thoroughly, and we'll now we'll bring the statistics required, so as we finalize the bill, we'll have look at this, some empirical based on for the decisions we take. But it's the gangs are made a challenge, and they change it's an ongoing situation, because some of this have changed already significantly. Certainly members of some of these gangs are now in detention, where they'll come to trial or not. I think in one case, I think we have 30 of the 30 plus members of one of the named gangs here now incarcerated, and some of the leadership of others are in detention, I guess, awaiting development of the case and trial, while other gangs have emerged, which are creating havoc in other communities. It's ongoing, and that's not a ballooning effect. It's just that other gangs have grown in the last 2 years quite significantly. But
Chairman, and again, it may be helpful to find out what criteria are applied in categorizing gangs as major or minor. Is it the number? Is it the level of involvement, the kind of offense? I don't know, but it may be helpful for
criminal
us.
activity is what's there, but we'll have to get the specific things for you. Mr. Taylor.
Mr. Chairman, well, if I may just be able to address some of the concerns. We can't speak to the 448 number. We don't know where that figure comes from, who computed it, or what it is related to. We can only speak about the matters that we know that we presently have before the court. Now, right now, we've taken a policy decision that many of the gang cases, no matter where they arise in the island, we transfer them to Kingston. Precisely because the Home Circuit Court has better security than an ordinary court out there in a rural parish. So there is that. There will be a delay in trying these matters because a policy decision has been taken by the court, and some that we had recommended. You can't have so many gangs on the Supreme Court building at the same time. You have to stagger when you bring them to court to mention their matters. I give an example. You are already aware, it's probably a notorious fact, that the Klansman gang has broken into many different factions. You can't have all those factions on the building at the same time. So you have to stretch out, and when you're setting trial dates now, and the date of trial date certainty, you have to estimate how long this trial will last, and so we've been trying to spread out the matters as much as possible because of the security considerations. I really don't want no bloodletting in the holding area among all the gang members. There are also witness considerations also. Like we say, we have people who are basically accomplices. We have to be doing special measures, applications to take their evidence by video link. It would help if we have also witness anonymity, but that is a discussion for another time. But these are also all other considerations that we're dealing with. We have been dealing with, in fairly recent times, a number of bail applications that are being made for them. So we have Crown Counsel, I have one here beside me, who has had to go to court more than once to respond to applications for bail in relation to them. So it's not like nothing is being done. The cases are going to take some time to come to trial. Delay, because of the nature of the case and the resources that we have and the security considerations, delay is inherent and inevitable in how these cases are going to be dealt with and disposed of. It's about how much we have presented before the court.
About 16.
I know we have about 16 or so matters. Some matters have had to be consolidated because when we evaluate the evidence, they're really arising out of the same incident. So where we had more, we've actually merged them. So the trials are going to become bigger and they're going to become longer. So we're going to have on average maybe about 20 odd persons being tried at the same time. Numerous lawyers, evidence to go through. So these trials will not be short when they start, and we have a culture among our defense counsel, they don't agree anything. So it's matters that are not in issue will not be agreed. The Crown is put to proof on everything. So those are just some of the considerations when we're speaking about trials, why there really haven't been any convictions as yet or so on. It's going to take some time.
Chairman, one point, sir. Witness anonymity, he mentioned. We do have special measures allowing for audiovisual evidence from remote locations, which is now in use. I'm wondering whether, and this is really for the technical team, whether we could include a provision in this legislation to say that the minister may make regulations subject to affirmative resolution for arrangements relating to witness anonymity, which would allow, rather than having to develop legislation and bring it here, it would allow, even on an interim basis, though some regulations to be made that would enable in gang cases witness anonymity orders to be made by the court.
I like that comment. I'd love to hear the lawyers, because I know that the Ministry of Justice is discussing such legislation, but until that is ready, I'd love to hear what.
Actually, Chairman, the committee, this had been raised before by a few members of the committee, and in fact, if you go to page 18 of the report, there is something there highlighted because we were supposed to present our findings. So we had done a little research. I don't know if this is an appropriate time or later when we get to page 18.
When we get to page 18, I
that we
forgot
could
that.
discuss it in some more detail because we have done some research.
Yeah, all right.
And just before we go to the findings and recommendation, and as a precursor, I'm inclined to the view that much more needs to be done to improve public confidence around the handling of these kinds of matters. I think there is a lot of ignorance in the public domain, including among those who seek to be opinion makers. And their pronouncements oftentimes deal a serious blow to confidence in the justice system and the handling of these cases when they really are ignorant about the realities that must be taken into account when these matters are brought before the court and even before during the investigative stage. And certainly part of the recommendation has to be to find some mechanism as part of the confidence building or as part of debunking some of the things that are said in the public domain which creates either panic or strike a blow to the confidence of persons in the system handling these matters. Would you say, Mr. Taylor?
Attorney General, I think you put it far more eloquently than I could ever do. And as the people's representative, I think you have a much greater bully pulpit than I have.
Well, and the AGC will help me to guide it, because I do think we have to do more in terms of educating the public. I'm not sure what approach I take it, but as I go through this legislation and some of the activities surrounding the security issue, I realize without condemning the dichotomy I referred to earlier, part of that comes from a lack of understanding and appreciation of what's happening, not only to the police, but to the courts and all the institutions we have that have to deal with the criminal justice system.
Just thinking, and Member Golding had touched on it, if this committee accepts in a formal way a lot of what we already knew, that this is truly the top tier threat, then it means it cannot be business as usual on every front.
I think we have gotten to a point where a large sector of society will accept that, and this committee accepts that. Is how we get that engaged in legislation that benefit. Right. I think certainly what we have to examine now, what can we introduce, for example, those raised in legislation that strengthens the capacity of the police to prosecute and give the DPP the requisite evidence that can go to court to get a successful conviction. All right.
All right, Minister, so I've been deputed the duty to continue the reading. So here comes the second lesson taken from page 7. Chapter 4, Findings and Recommendations, Part 1, Preliminary, Section 1, short title. Your committee notes there were no proposals for Section 1. Section 2, Interpretation, Definition of Court. Your committee notes a proposal from the Ministry for the definition of court to be amended to replace resident magistrates RM court with parish court. Your committee notes that all references to resident magistrates court in all laws have already been amended to the parish court in pursuant to, well, take out the word in, pursuant to the Judicature Resident Magistrates Amendment and Change of Name Act 2016. Your committee decided not to accept the recommendation because the Judicature Resident Magistrates Amendment and Change of Name Act 2016 had already addressed the name change. Yes, done. Definition of criminal organization. Your committee notes a proposal from the Norman Manley Law School for the wording of the definition of criminal organization to be examined and reorganized on the basis of any association of 3 or more persons, whether formally or informally affiliated or organized, so that the need to prove a gang or alliance would not necessarily arise. Your committee did not accept the recommendation. Definition of law enforcement officer.
Chair,
Yeah.
Sorry to interrupt you, member. I'm just wondering, Chair, if on the definition of court, your committee notes a proposal from the ministry. Is ministry to be understood in this report as the Ministry of National Security? Yeah, it's already. Okay. All right, thank you.
So let's clarify.
To go back to that, I think in respect of the definition, although the amendment and change of name would apply, it's in any reprinting of the law that the correction would be reprinted. Yes, yes.
As the revised laws are updated. Definition of law enforcement officer. In relation to the proposal from the Norman Manley Law School to amend the definition of law enforcement officer in the Act, your committee decided to accept the recommendation to delete paragraph B of the definition, thereby removing the reference to Island Special Constabulary Force, since the merger of the Island Special Constabulary Force into the Jamaica Constabulary Force had already been effected administratively. Definition of benefit. Your committee notes the recommendation from the Norman Manley Law School that the term benefit in the Act has a wide definition and is too vague. They raise queries regarding the meaning of service or advantage, whether an ordinary citizen would know if he gives someone a ride or helps a neighbor that he's providing a benefit to a criminal organization. Your committee agreed that the definition of benefit should remain as is and did not accept the recommendation. Definition of recruit. Your committee notes the recommendation by the Norman Manley Law School that whilst it was commendable that the word recruit is defined, the various words in the definition are broad. For example, coerce can mean force, pressurize, compel, bully, intimidate, drive, or persuade. Sections 4 and 5 would make it a criminal offense to try to persuade a child or adult to become part of a criminal organization. The act of persuasion alone should not be sufficient, as the Constitution and Charter of Fundamental Rights and Freedoms guarantees freedom of expression. Your committee agreed that the definition of recruit should remain as is and did not accept that recommendation. Definition of serious offense. Your committee agreed that the term serious offense should be deleted from Section 2 and replaced with the term applicable offense. Accordingly, consequential amendments will be required throughout the Act to give effect to the change in the term from serious offense to applicable offense. That's a whole heap of changes.
Shouldn't that
just
be a
for a term,
recommendation? I mean, it shouldn't it be stated?
I personally am not persuaded that that's necessary.
That was your suggestion, Member Golden.
What?
The applicable offense as opposed to serious offense.
No. I don't think it's necessary to make any change at all. It's just a defined term. It's just a label. Serious offense is just a label for a clutch of offenses which are in the schedule. And that schedule can be amended from time to time, as I understand it, by ministerial order, so that if you want to add something to it, you do.
But I do
I think the
recall.
reason why the thing came up was because out of the Uchens, whatever the name, trial, there was a letter from the DPP's office, I believe, saying that one predicate offense, which they would have liked to have been able to treat as something that a gang can get into for anti-gang prosecution purposes, was it well, it was some relatively minor offense. I can't remember which one it was. Simple larceny. So the inclusion of that in the schedule was felt to mean that that's not really a serious offense. But a serious offense is not a term of art in law, you know. It's not like it means it's a trial, an indictment or whatever. So to me, this is just going to necessitate a whole heap of changes right through the body of the legislation.
Giving name to the
label.
gang. Giving, well, the gangs, given nature of gangs, they in fact involve in a wide cross-section of activity, some of which are simple criminal offenses that are tried as a predicate offense that are tried almost a petty session, but you want to bring them on the Anti-Gang Act, so I guess applicable offense would be more appropriate in the long term.
Yeah, it would. It's just, I don't think it's necessary. But anyway, it's in the report. I'm not making any bigger deal of it.
Chairman,
Yeah.
I actually share your view and part company with Member Golding, because in reality, there are a number of acts currently categorized as minor offenses that are committed by persons who associate themselves for criminal activity, and they create mayhem for public order, and they are emboldened with the small things to then carry out their bigger acts. Any of the public order, abstracting electricity, if they themselves do not commit to the act of, say, robbery with aggravation or burglary or housebreaking or anything, they then get the largesse of it. So that it's a difference in concepts, not just terminology. When you look on the whole, the landscape, the minor things, the breaking of the traffic laws, all kinds of things. And it's counterintuitive because for a long time we have focused on the bigger things and have left the ground level, the foundational misconduct and misdeeds to just go awry. And it is at that stage that people do their wrongs and become emboldened because they do it with impunity. So it's not just cosmetic, it goes to something more fundamental, and that needs to be understood.
But I think that's kind of on a different tangent. The question is whether persons associating together, 3 or more persons for the purpose of committing offences, should be prosecutable as under the gang legislation. Now, the idea of persons, 3 or more persons associating together to commit traffic offences, I don't think that would be certainly what wasn't originally contemplated as being something prosecutable under this. They could be prosecuted for conspiracy to breach traffic offences if that was considered desirable.
The illustration brought by the word is more valid because when you get a community that begin to extract electricity, it becomes a part of that turf is controlled by that gang. Nobody goes in there to disconnect it except the police because they're afraid, and in fact people pay the gangs to supply electricity. It does happen. And on
the abstraction of electricity in communities across Jamaica, underprivileged, for want of a better word, communities, is a socio-economic
I hear what I'm just saying. That happens, but
doesn't
it can
necessarily
become,
have anything to do with gangs.
That's why I treat it as simple criminal act, but it can become a business venture of gangsters, and it has become, because when you abstract electricity, is in terms of one man getting 2 pieces of wire and throw it on a line is one thing. There are communities where a criminal organized will buy light poles and run light in the direction and then charge those who take from it a flat rate, which is far more than what the JPS charges. They make money from it.
And just to say though,
that is not a scheduled offence.
If what the member expresses his understanding of what I said, then he has clearly misunderstood, because by no means am I suggesting that 3 or more persons associating should be prosecuted for breaking the stoplight. But as the senior deputy said, when you consolidate matters in order to look at the entire suite of conduct or misconduct, you must be able to place all of the allegations before the court with the likelihood of any of the many being returned by way of conviction. So that is a clear misunderstanding, what you have expressed.
The question is, what is an anti-gang offence? What is an offence that's chargeable under this act? And it's associating together to commit certain types of offences. I can amend the schedule.
The relevant minister can amend the schedule to add them.
Yes, you can.
So whether you use serious offence or applicable offence, it doesn't make a difference. If whether you use the term serious offence or applicable offence, does it make any legal difference?
I don't think it's one is just a more relevant or appropriate way of expressing the list of things. If you're going to include in that list really what would generally be regarded as minor offences, because the phrase used here in the law is serious offence. So I'm not hostile to it. I just think it's a major sort of surgical exercise of because the phrase serious offence is probably all over the act, and so you're going to have to change every single one of those references. It's just a law revision issue, so I think we can move on. Part 2.
Sorry, excuse me. Sorry, you're making it.
What is the recommendation?
I'll just ask you to look at page 25 of the report that gives more context to this whole discussion of serious offense. And you will then recall how, again, the whole discussion arose based on a submission made by the Officer Director of Public Prosecutions. And so what we were recognizing, it's not a cosmetic issue at all. We're recognizing now that there is a morphing. We're moving from the original intent of the law into something a little different because of how it's just the application of the act and the use of the act and the whole point of this review, and noting that the ODPP had indicated that there were other offences that were now that they really thought should be included in the first schedule, and there was some concern about whether those offences would really be properly considered serious offences. Noting that we are now having understood how the Act is being used, the kind of charges that can be laid, and the way in which a prosecution has developed, that perhaps we should have moved away from this concept of just serious offenses. So this is a reason. So I think if you look through page 25, it will give a
I've
better
seen it,
context.
and I think it's another way of expressing what's already just been said. The idea is that, well, all I was saying was serious offense is not a term of art. It's not like indictable versus summary or felony versus misdemeanor.
Right.
It is a descriptive term. The point is taken that the way that this is
other words,
moving, you're going
if
to
I
be
get you
including
right,
things in
so-
the
sorry,
schedule.
remember, if I get it right, if a gang is involved in an organized simple larceny as
Yes.
part of the activity, it becomes a serious offense.
Well, I would say it does, but I think the point is that simple larceny is not perhaps generally called a serious offense. So the phrase, the defined term, serious offense, if you're going to have in the schedule things that are not generally regarded as serious offenses, then it's best to change the label to something that is more generic, like applicable offense.
If I may-
It's cosmetic in that sense.
If I may, in fact, one of the committee members had indicated that simple larceny is not a serious offense. So the discussion happened among the committee members as well.
Saying simple larceny was not generally considered a serious offense. So if you're going to be including in the schedule offenses like that, abstracting electricity and so on, that most people would not call a serious offense, then the label in the Act, which is used for the list, the label of what is in that list, it needs to be made more generic.
If I may add, Chair.
We accept. I think that's the decision of the committee, and we'll stay with it.
Yeah, if I may just add, Chair, to what the SG has indicated, that there was actually considerable debate on our side in relation to that, and there are some who are of the view expressed by Member Golding, but I think the consensus was that, given all of what has been said and by the SG, that the term applicable would perhaps be a better term, and that would avoid some discussions as to whether something is serious or not.
It is. I'm just saying I don't think how you term it is particularly meaningful. It's better descriptive language to use applicable. That's what it is. I just don't think it's just a label. It's not like anything more fundamental turns on it than that. But I agree it's a better way of describing the list.
But I also would add that one of the, in terms of the nature of an offense and gang-related activity, we know, for example, an example from Melbourne in Australia, where there is a gang that flies from Beijing to Melbourne to beg on the streets. It's illegal to beg in Melbourne, but it has become a gang activity. And we have that example. So what kind of offenses that gangs may be involved in is not determined by whether or not it's maybe seen as serious or minor, but what is as lucrative and profitable for them.
Since we are agreeing that it shouldn't detain us, and subject to any fault in my recollection, we do have case law which speaks to serious and minor offenses, where you have a major offense and you're allowed to return a conviction for a lesser offense. So the terminology has been used in case law, where you have the major offense and you're allowed to return a conviction on the minor offense. So it is a term of art in some places, yes, within our jurisprudence at least.
Anyway, I don't agree with that, but we can move on. Part 2, offenses for the disruption and suppression of criminal organization. Section 3, offense of forming or establishing of a criminal organization. Your committee notes that there were no proposals for Section 3. Section 4, offense of recruitment of child to a criminal organization. Section 4.1, a person shall not recruit a child to be part of or participate in a criminal organization. Your committee notes that the proposal of the Norman Manley Law School that the act of persuasion alone in recruiting a child to be a part of a criminal organization should not be sufficient to warrant a criminal offense, as the Constitution and in particular the Charter of Fundamental Rights and Freedoms guarantees freedom of expression. Yeah. Your committee did not accept the recommendation. And the sentence, maybe I read it, it read peculiarly, but that's just a grammar issue. Your committee notes the proposal of the Major Organized Crime and Anti-Corruption Agency, MOCA, that an aggravating factor should be considered in sentencing where recruitment of a child is deliberately done and involves the child performing some atrocity as a rite of passage. We note that in the process of recruiting a child, if there were acts of violence or intimidation committed, that ought to be an aggravated factor in sentencing an individual for committing the offence under this section. In our deliberations, we determined that an aggravating factor should result in an additional custodial penalty, not exceeding a term of 10 years for the offence. Your committee decided to accept the recommendation that acts of violence or intimidation committed in the recruitment of children ought to be an aggravating factor in sentencing.
Seek some clarity. It's two different things were being said in that discussion. So where you recruit the child using acts of violence, and where as part of the initiation the child is required to do some atrocious activity as a rite of passage. I think this doesn't quite capture the two. Just for clarity, if the recommendation is that on both counts, there would be aggravating factors.
Thank you.
Sorry. AG, I don't think the minutes recorded the decision in that way, so perhaps the committee can just decide no then, and then it can be recorded.
Clear one is if you use violence and intimidation to recruit, like you duress, or to frighten a child or whatever, that should be an aggravating factor in the sentence in relation to the offence of recruiting. The other issue is whether, if in the course of joining a criminal organization somebody is required or expected to commit an act of violence or intimidation, whether that should be a aggravating factor. Now, is that in relation to the recruiting that becomes an aggravating factor, or is that in relation to the gang activity inherent in that rite of passage? It's not as clear to me how that it connects with the recruiting. It may do, but I'd just like that to be clarified.
I think maybe that's right. The first item is fairly clear. Violence or intimidation are aggravating factors. I think that must be included in the law. The second point, the rite of passage, is a little bit, I think it's worthy of consideration, but it's how we define it, because, and in relation to what? It's not just a matter of violence, but for example, young men will use school children to carry the firearm. What do you consider that? That's a major, it can become quite a systemic activity, moving from point A to point B, which is part of gang operation. And it's not a simple matter. It ends up being that young A will have a child who is quite innocent attending school in an area close to gang B's turf, and the person to carry the gun there is the child. How do we treat that as part of such a matter is recruiting a child into the gang, where it's used to begin to get the children involved in gang activity. So, but they're, a gun stuck in a 9-year-old school bag is less likely to be searched than an robot taxi, white Nissan AD or Corolla, driving from Linstead to Spanish Town. And that to me, and in many cases, those are the way youngsters are recruited into gang, because they start by carrying the firearm or other products on behalf of the gang from point A to point B till they get big enough to do other things on behalf of the gang. How do we treat that aspect of it in the legislation? That's recruitment. Well, that's I was wondering. The use of violence or intimidation is clear, but I'm not seeing clearly how, if recruitment is fully defined, rite of passage is maybe shooting somebody. But recruitment, would carrying a firearm, or, you can see recruitment generally is a crime, but say carrying a firearm, would that be an aggravating SG? Would we define the additional aggravating circumstances in sentencing? Certain rite of passage should be an aggravating circumstance. Aggravating factor. If a big gang take a look at 13-year, 14-year-old youth, as a case, give a youth who's about 14 a firearm to shoot his uncle, and him start practicing and shoot somebody else by accident.
Chairman, I was just trying to look through because we had the report has reflected decisions of the committee in relation to what would be an aggravating factor when sentencing someone convicted of various offenses. I was just trying to find, because I think it runs throughout the report.
The recruitment is a crime in itself, but I'm saying you should maybe add as an aggravating factor, besides violence and intimidation, any inducement to use a firearm or to.
Sorry, Chairman, just give us a few minutes because I remember seeing it, so I thought,
the
yes,
use of a firearm,
that point,
okay.
but
Right
I'm
of
just trying to
passage
find it now.
It's not just a rite of passage, but I think as we look at the reality in a more relaxed mood, the gangs and the guns are the core, and the use of firearms is the core of our criminal problem, or the homicide problem in particular. So I think wherever those two show up, we ought to send a strong message that the penalty will not be exactly routine. I'm saying AG, look at that. AG will allow you to go to report, but I think we accept the violence or intimidation. AG will take advice if we think we need to look back at any further activity to be included. I'm going to read section 4.
But Chairman, sorry, if you could then maybe, I would suggest if the committee wants to add something, that this would be the appropriate time to do it.
Well,
if you want to include an additional aggravating factor.
Generally, that any use of violence in the recruitment and initiation of gang membership.
No, I think we accept it. I was just saying that if they induce them to use firearms,
right,
which is not like taking a firearm to school, putting a firearm in a child's bag to go to school. That's part of the recruitment process.
So I would say recruitment including initiations for membership.
Yeah.
Something along that line.
Yeah.
Which would cover
broaden a little
both
bit to count those things because
scenario.
that's how they bring them in, and they get money for it. You know, in a depressed community, someone taking a firearm from point A to B, and the families ensure that tax-free and lunch money is available is a big inducement. This Ms. McCarthy's asked to repeat that, AG, in a context she can. AG, she's asked to repeat that sentence so we can.
Saying we could find formulation, but the general recommendation would be to view the use of violence in the recruitment and initiation for gang membership. That would include any rite of passage, to be considered as an aggravating factor in sentencing.
All right. Senator, you want to read first
so
from
if the evidence is that in recruiting X, whatever the level of violence that is used, and in addition requiring him to use violence as part of any rite of passage before he is initiated as a member of the gang, then that evidence would be aggravating factor.
Thank you. 4-2.
4.2.
Yeah.
A person who contravenes subsection 1 commits an offense. Your committee notes there were no proposals for section 4.2. Section 5, offense of recruitment of adult to criminal organization. Section 5.1, a person shall not recruit an adult to be a part of or participate in a criminal organization. Your committee notes the proposal of MOCA that the aggravating factor in Section 4 be extended to Section 5 for the recruitment of an adult within the vicinity of a school, 300 meters. Your committee notes that currently there is no aggravating factor to address the recruitment of an adult, but that if this was done within the vicinity of a school, then this might have an impact on impressionable minds in a school, and such activity might influence the children how they think, as well as amenability to themselves being recruited into gang activity. Therefore, in order to send a strong signal to gangs regarding the recruitment of children or adults in the vicinity of a school, a proposal was made that such recruitment should be considered an aggravating element to the sentencing. Some members were of the belief that where the recruitment of an adult takes place is not relevant, that there was no overwhelming preponderance of evidence presented to the committee that suggested that this was a problem, and in any event, a judge would have the discretion of sentencing, taking into consideration all the circumstances. Your committee agreed that Section 5.1 should remain as is and did not accept the recommendation. Anything, AG? 5.2. A person who contravenes subsection 1 commits an offense. Your committee notes there were no proposals for section 5.2. Section 6. Offense of being a part of, participating in, or facilitating the commission of a serious crime by a criminal organization. Section 6.1. A person shall not A. be part of or participate in a criminal organization, or B. knowingly facilitate the commission of a serious offense by or on behalf of a criminal organization. Your committee notes there were no proposal for Section 6.1. Section 6.2. A person who contravenes subsection 1 commits an offense. Your committee notes there were no proposals for Section 6.2. Section 6.3. Subject to subsection 4, in determining whether a person is a part of or a participant in a criminal organization, the court may take into account all factors that appear to it to be relevant, including A to F. Your committee notes the proposal of the ministry to make it mandatory rather than permissive for the court to consider any one or more of the factors listed in 6.3 when determining whether a person is a part of a criminal organization. Your committee agreed that the word shall should not replace the word including, and therefore did not accept the recommendation. Your committee notes the proposals of the ministry and the Jamaica Constabulary Force to amend Section 6.3 to include an additional factor that the court consider whether defendant had gang tattoos or had gang paraphernalia in his possession when determining whether a person is a part of or a participant in a criminal organization. Your committee accepted the recommendation and decided that Section 6.3 should be amended to include any identifying signs and symbols that indicate being a part of or a participant in a criminal organization and could be added as paragraph H. Your committee notes the proposal of the ministry to remove the word and substitute therefore the word or at the end of Section 6.3f. Your committee did not accept the recommendation but agreed to remove the word and, which appears after the word organization from Section 6.3f. Section 6.4.
Just asking, remind me of what that interpretation will mean, that they are not to be viewed conjunctively, but disjunctively. So you would need to put, if the substituting the And with or. It could be both. Just
If
remind
we had
me.
put or, it meant it would just be one.
And if you take it out entirely, it could be used in
It can
conjunction
be- it
or
can be
singly.
cumulative, yes.
Just making sure that the intention is clear. Yes.
Section 6.4. Notwithstanding subsection 3, the community in which a person resides shall not be a factor in determining whether the person is a part of or a participant in a criminal organization. Your committee notes there were no proposals for section 6.4. Section 7. Offense of leadership, etc., of criminal organization. Section 7.1. A person shall not A. lead, manage, or direct a criminal organization, or B. knowingly counsel, give instruction or guidance to a criminal organization in furtherance of its participation or involvement in criminal activity. Your committee notes there were no proposals for section 7.1. Section 7.2. A person who contravenes section 1 commits an offense. Your committee notes there were no proposals for section 7.2. Section 7.3. In determining whether a person has committed an offense under this section, the court may take into account all factors that appear to it to be relevant, including A to C 1 and 2. Section 7.3a. Evidence of the possession by that person of articles or documents of a kind that would give rise to a reasonable inference that the articles or documents were in his possession or control for a purpose connected with an offense under this section. Your committee notes the proposal of the Jamaica Constabulary Force for the amendment of Section 7.3a to include as an additional factor that the court should consider whether the defendant had gang tattoo or had gang paraphernalia in his possession. Your committee did not accept the recommendation. Section 7.3b. In determining whether a person has committed an offense under this section, the court may take into account all factors that appear to it to be relevant, including B, whether the person knowingly received any benefit from the criminal activity of the criminal organization. Your committee notes the proposal to remain consistent with the amendment proposed in relation to Section 6.3, that a similar amendment was taken at Section 7.3b. Your committee accepted the recommendation to remove the word "and," which appears after the word "organization" from Section 7.3b. Section 7.3c. Any document emanating or purporting to have emanated from the criminal organization from which it can be ascertained or reasonably inferred that when an offense was alleged to have been committed, 1 and 2, your committee notes there were no proposals for Section 7.3c. Section 7.4. Subsection 1 shall not apply to a person who counsels or gives instruction or guidance with the sole objective of encouraging participants in the activities of criminal organization to desist from engaging in any criminal activity. Your committee notes there were no proposals for Section 7.4. Section 8. Offense of providing a benefit to or obtaining a benefit from a criminal organization. Your committee notes there were no proposals for Section 8. Section 9. offense of concealing, etc., proceeds of criminal activity of criminal organization. Your committee notes there were no proposals for Section 9. Section 10. Offense of aiding and abetting, etc., criminal organization. Section 10(1). A person shall not knowingly aid or abet a criminal organization or become an accessory before or after the fact in carrying out of a serious offense by a criminal organization. Your committee notes the proposal from the Office of the Director of Public Prosecutions for additional offenses in relation to persons who counsel, give instructions or guidance, finance or otherwise provide support to gang members, as well as to afford law enforcement personnel the right to search and seize documents they might have in their possession. Your committee did not accept the recommendation.
Mr. Chairman, if I may, just to go back to Clause 8, offense of providing a benefit to or obtaining a benefit from a criminal organization. I know that at the time when the report came out, the Office of the DPP had, well, we submitted certain recommendations afterwards. And we had actually submitted a recommendation for amendment to Section 8, which we proposed the removal of the "and" in relation to the factors that the court would consider, because we found that having those two factors there linked by the "and" made it difficult to prosecute because they were conjunctive. Both elements would have to be present before the court could consider the whole thing of whether or not a benefit had been provided to a criminal organization. And our suggestion was that the "and" should be removed from Section 8, Subsection 4A, and replaced by an "or."
The "and" or wouldn't work? Both? One or the other or both?
What we prefer, "or," you know.
Okay. So we at least have one.
Difficulty with the suggestion. I have no difficulty with the suggestion.
So
And
it would read disjunctively rather than conjunctively.
But just to ask Madam CPC whether just deleting it would allow for flexibility instead of, so it's a matter of the drafting and interpretation.
Yes, AG. So consistent with what we had done before, it would simply be the deletion of the word "and" we would not be substituting the word "or."
Although, Madam CPC, I do recall a very weird statement from the bench about it not being left to the judge to have to exercise interpretation functions. And so that
And AJ,
drafting.
I suspect that comment crept into the judgment.
It did. So we now have something. So we will just have to look again. So if the intention is not to make it conjunctive, then we'll just take a fresh look at it for interpretation purpose. Because we don't want to defeat.
It being a criminal statute, they usually tend to be construed very strictly.
I know.
And almost literally. So if the "or" will not cause any violence to it, we prefer the express use of the word "or."
Mr. Taylor, just to say that I'm inclined to agree with you, because what we thought was standard and what was established in case law, we're finding some very strange pronouncements, creating hurdles for proof. And the intention is not to create hurdles for proof. So we will look at it. So we will accept that a recommendation that the intention or a change in intention for the provision is to make it disjunctive, and then we will look at let's just look at it. So we can either take it out or the CPC can determine how best. But I understand that consistent with earlier, taking it out should cause the court to construe it as disjunctively.
That's what the purpose of the word including in the chapeau is for. So in this case, having an and or is immaterial or should be immaterial to how it's interpreted there.
Should be in the operative word, Madam CPC, but we will deal with it. So the recommendation to delete the and is accepted to prevent the need for proving both elements before conviction.
And AG, I suspect that this discussion is being recorded so that if it ever needed to be explained, the intention of Parliament, we do have something on record now.
Have to resort to the secondary or tertiary rules in order to be clear, but just in case there is a need for it, then we could always resort to the Hansard.
I was just wondering, since this is basically a committee of the Parliament.
Well, when the report goes to the full House and it is accepted, and there is amendment to reflect it, yes, it will apply all the way back, procedurally.
Continue.
Section 10.2. A person shall not harbor or conceal a person, knowing that the person is a part of or a participant in a criminal organization. Your committee notes there were no proposals for Section 10.2. Section 10.3. A person shall not, in order to promote or facilitate the criminal activity of a criminal organization, incite or induce another person to A, commit a serious offense, or B, engage in an act of violence or an act that serves to intimidate others. Your committee notes there were no proposals for Section 10.3. Section 10.4. A person shall not, in order to hinder or prevent the investigation or prosecution of a criminal organization, incite or induce another person to A, commit a serious offense, or B, engage in an act of violence or an act that serves to intimidate others. Your committee notes there were no proposals for Section 10.4. Section 10.5. A person shall not conceal, transport, dispose of, or tamper with evidentiary material relating to the criminal activity of a criminal organization. Your committee notes there were no proposals for Section 10.5. Section 10.6. A person who contravenes subsection 1, 2, 3, 4, or 5 commits an offense. Your committee notes the proposal of MOCA that the aggravating factor be extended to section 10.6 for section 2C. Am I reading that correctly? For section 2? Yeah. It says that last part, your committee notes a proposal of MOCA that the aggravating factor be extended to section 10.6 for is what comes there. Something, there's an error there. Not reading right.
Senator, I think it was just an error where you see section 11 and the C.
Yes.
That should be deleted because I think it reads be extended to section 10.6 for the incitement or inducement of a child.
Okay.
I think it was just a...
So it should be extended to section 10.6 for the incitement or inducement of a child, full stop. That
Yes,
would have
I
been
think
it.
that was just a typo.
And then section 11 would read from where of the belief?
Just continue. Just delete where you see section 11C because 11 is...
So ignore
is,
that.
Yes, yes.
Okay. Your committee, okay, section 10.6, a person who contravenes subsection 1, 2, 3, 4, or 5 commits an offense. Your committee notes the proposal of MOCA that the aggravating factor be extended to section 10.6 for the incitement or inducement of a child. We are of the belief that if the person incited or induced is a child, that ought to be an aggravating factor wherever it occurs and should not be co-joined with a particular location within, such as within 300 meters of a school, which was recommended by MOCA in order to become an aggravating factor. Your committee did not accept the recommendation but agreed that the aggravating factor should be extended to subsection 10.6 for the incitement or inducement of a child and should not be co-joined with a particular location.
Just a correction, it shouldn't say subsection, it's section 10.6. Just another typo.
But my understanding, again just for clarity, is that a recommendation was made that where recruitment of a child takes place within a certain distance of the school, that should be regarded as an aggravating factor. That was not accepted on the basis that if you recruit an adult anywhere, it was an offense. So the recruitment of a child, regardless of where it takes place, should be regarded as an aggravating factor?
No, it's an offense, but the aggravating factor is if it is within a certain distance from a school.
But wasn't that recommendation rejected?
Not for 10.6. Huh? Not for 10.6. The committee had this discussion more than once.
So section 10 itself deals with aiding and abetting, etc., of criminal organization. I'm not understanding. This just lacks a little clarity for me.
I think because 10.1 deals with everybody, adults, children. So in this case, the aggravating factor would relate to where the person is a child. And then, so the reference to the location would not be applicable here because you're just dealing with, yes.
Yes.
Just let's clarify.
Okay. Section 11, offense of professing to be a part of or participant in a criminal organization to obtain benefit. Section 11.1. A person shall not, in order to gain an unlawful benefit, profess to be a part of or a participant in a criminal organization, whether by telling any person that he is a part of or a participant in a criminal organization, or otherwise suggesting to any person that he is part of or a participant in a criminal organization. Your committee notes the proposal from MOCA that the activity taking place within 300 meters of a school should be extended to section 11, which is incitement or inducement of a person to commit a serious offense or an act of violence. Your committee agrees to the deletion of subsection 1 and substitute therefore the following. 1. A person shall not, in order to gain an unlawful benefit, profess to be a part of or a participant in a criminal organization, or to be acting on behalf of or on the instruction of a criminal organization, whether by A, telling anyone that the person is a part of or a participant in a criminal organization, or is acting on behalf of or on the instruction of a criminal organization, or B, otherwise suggesting to anyone that the person is a part of or a participant in a criminal organization, or is acting on behalf of or on the instruction of a criminal organization.
Chairman, just to say that I do believe it really should be in order to gain a benefit, not an unlawful benefit, because it's a process by which you gain the benefit that would then make it unlawful in the circumstances.
Yes.
Unnecessary hurdle.
Redundant.
No, it's not. Redundancy is an unnecessary prosecutorial hurdle.
We were just having the same discussion here, Attorney General.
Maybe it's the prosecution mind.
If unlawful is mere surplusage here, or if it's not, why not just a benefit alone, Section 11.1?
Accepted. She's
Not
going back to
Chairman.
she's going back to the prosecuting role. Mr. Taylor.
No, we take her back, you know.
Benefit, yes. Not unlawful benefit.
I 115. All right, give us some more. Look like we'll have to do a bit more.
Section 11.2. A person who contravenes subsection 1 commits an offense. Your committee notes there were no proposals for section deleted. Your committee notes there were no proposal for section 11.2. Section 12. Offense of preventing, etc., person from ceasing to be a part of or a participant in criminal organization. Section 12.1. A person shall not take any action to prevent, deter, or obstruct a person from ceasing to A, be a part of or a participant in the activities of a criminal organization, B, provide a benefit to a criminal organization. Your committee notes the proposal from MOCA that the aggravating factor be extended to Section 12, which was incitement or inducement of a person to commit a serious offense or act of violence in respect of a child. Your committee did not accept the recommendation, but agreed to recommend that it should be an aggravating factor in sentencing a person found guilty of an offense under Section 12, where the activity is to prevent, deter, or obstruct a person from ceasing to be a part of or a participant in the activities of a criminal organization is in respect of a child.
Sorry, just another little typo. I would take out the is. Where the activity, I would take out that is there, since we have
Activities
where the
of a
activity,
criminal
where the activity to prevent in the line above. I would take out that is, since we have is in respect of a child.
in this. Okay.
Chairman, again, just to say that one of the other Joint Select Committees reviewing the Sexual Offences Act, I'm not sure where it has reached, but I do know that at an earlier stage there was a policy agreement that a child, like others, the elderly, regarded as vulnerable, and where offenses include those persons, then it would be an aggravating factor. And I'm beginning to wonder, there was a time when we legislated criminal justice administration generally, and so we would know what to apply without having to descend in particular pieces of legislation. So, you know, once you're dealing with children, elderly, and other recommendations. And I'm wondering if it doesn't continue to make better sense that we do it that way. And this is not to say we take out these recommendations. Can't hear you, Madam Solicitor General. I suspect you're saying the work is not advanced on that front yet, and this work is ahead.
Section 12.2. A person who contravenes subsection 1 commits an offense. Your committee notes there were no proposals for section 12.2. Section 13. The offense of taking retaliatory action. Section 13.1. A person shall not take any retaliatory action against another person or any other person's relatives, friends, associates, or property on account of that other person, A to E. Your committee notes the proposal from the Jamaica Constabulary Force to allow for a person who is a target of criminal organization to be placed in the care of the state with his or her consent. Your committee did not accept the recommendation and decided that the issue should be undertaken administratively. Section 13.
But this is where the issue of to allow for a person who is the target of a criminal organization to be placed in the care of the state with his or with consent.
Chairman, I confess to a completely different view, particularly since I'm in the role of parents patria. I don't think the state has the resources to be obligating itself to take on so many persons, and we will end up incurring more liability. So everybody wants to pass over everything else to the state. Yes.
Administratively, what?
Right.
Put
it in law, although
clarify that for me.
depending on how deeply you put it administratively.
In other words, with his or consent, we do it not by legislation, but by consent. And in each case.
So if it's what kind of custody would that be?
I was thinking this kind of.
Because my head is looking at all kind of thoughts coming up now, especially the thought of false imprisonment.
If it's with her consent, yes, administratively, because we'll have to do it accordingly. But all right.
You have already in the Constitution preventative detention, so I don't know,
Section 13.2. A person who contravenes subsection 1 commits an offense. Your committee notes there were no proposals for section 13.2. Section 14. Offense of impersonating law enforcement officer. Section 14.1. A person shall not, in the furtherance of the criminal organization, A, put on or assume the dress, name, designation, or description of a law enforcement officer, or B, act or identify himself as or impersonate law enforcement officer. Your committee notes the proposal from MOCA to expand Section 14 to cover the possession of specific articles of dress and accoutrements and firearms that use high-caliber ammunition, with the addition of an enhanced penalty for the possession of these items. It was further proposed that these factors be considered as aggravating elements for the purpose of sentencing. Your committee notes the need for a provision to define high-caliber weapons, and that the commission of any offense using certain weapons should be considered an aggravating factor. Your committee agrees that a new section 14.1c should be added regarding use of high-caliber weapons that use high-caliber ammunition. Your committee recommends that the unlawful possession of the dress or accoutrements of members of the Jamaica Constabulary Force or the Jamaica Defense Force should be an aggravating factor in regard to sentencing of any person who is convicted of any serious offense was found. If any person who is convicted of any serious offense was found with these items.
Just AG a question here, back to the original question we had earlier. I see serious offense is used here, which is not an...
I was just about to go there. It really should be applicable offense, yes.
Yeah, you change it applicable, okay. Because it means if they commit a simple larceny in the dress of a uniform, yeah. I like the section of these guys traveling with assault rifles and drum magazines. They need to be treated differently.
Mm-hmm. If I may, Mr. Chairman, I'm just wondering, I wasn't here when MOCA proposed it, but why this couldn't be prosecuted under the Firearms Act, since they already can try the gang offences and firearms offences together. They can be joined. Depending on what use is made of it, there are mandatory minimum sentences already under the Firearms Act. Do we need to have something that specifies a high caliber weapon or high caliber ammunition, even though the Firearms Act already has certain categories such as prohibited weapons, prohibited ammunition, and so on already in its provisions?
I think we have to be careful. What you're saying is that we don't make it inconsistent or make it more difficult here or repeat something that is not necessary.
I was thinking more that Firearms Act already covers the possession of these kinds of articles without a license or a permit.
Well,
already.
Chairman, through you, one of the general concerns that arose during the deliberations had to do with recommendations for inclusion in this law where the misconduct was already covered in other pieces of legislation, and I think that's picking it up, as critical it is. But just to clarify, what is your recommendation through the committee?
Well, I am just wondering why it is needed, why even have a new legislative term such as high caliber weapons or high caliber ammunition, when already a lot of this are already covered under the Firearms Act on the existing legislation already. Is it the possession of it that is being criminalized or what?
Hold on.
No, if I may, Chairman, I do recall the discussion because we had raised the fact that you had the Firearms Act, and we also wanted to know how do you define what's a high caliber weapon? How do you define this high caliber ammunition? But members of the committee kept insisting that these were problems related to gangs, that gangs had certain types of weapons that they wanted to see it in this act. So we also weren't very clear on how it would be put in here, and I agree that we would have to be very careful to ensure that that we're not doing anything inconsistent with the Firearms Act, and I agree all of this would be already covered in the Firearms Act.
I'm just wondering, in light of parallel work being done, whether this is a little carrying over of some of what is being proposed under the amendment of the Firearms Act, but the question is a live one. Why put it here when it can properly be dealt with under the Firearms Act?
I remember that discussion, and committee members, they were particularly passionate about it. I think the justification was that it's one thing to have a family attacked with a 9mm, but when someone goes with a rifle and some other high-powered big name, they think that it's a different, it's now terrorism, right? It was put in that context, and therefore, I think that was it, and they believe that given the caliber, meaning people don't even stand a chance, that it should be. That was the discussion, I think.
Through you, while I understand what we are seeking to address, we do not now have a category of high caliber, if I'm not mistaken, even though we know what that may mean. We don't have it, and we have a piece of legislation that primarily deals with firearm offenses, and to create inconsistency in terminology or to duplicate a provision, I think is a bigger issue. So, yes, loosely we know the high caliber, but the Firearms Act does not so categorize.
The new act will do, because there is, in fact, in issuing a license, in fact, certain caliber weapons are not allowed to be licensed in Jamaica. Though I've been varying that for some time, or every now and again it's varied, but it's against they are defined in law, that, even for licensing. So there is, it may be not defined as, let me hear from Mr. Richards, if you're aware of this thing.
Yes, Minister. AJ, I think it's in the firearm amendments proposals. We have prohibited weapons, and that is defined. So if the recommendation is for us to change the high caliber to prohibited weapon, but I think the point that MOCA was trying to make in their submission was that once these high caliber or prohibited weapons are utilized in gang activity, then it could be considered as an aggravating factor. I think that's the point that is made in the recommendation from the committee.
But I agree.
The
What I'm
Firearms Act
Chair,
does not have
for it to be
make a
defined somewhere,
distinction, right?
I want to be defined somewhere. But I agree. You should not create legislation that contradicts another one or where it is already established. And I know the Firearms Act is supposed to be defining some of these, this high caliber weapon and whatever, and the accoutrements that go with them that make them more dangerous than regular firearms.
Just remind me, Mr. Chairman, so we can address this by just, so the question, just clarify for me again, Mr. Taylor, what was the issue you had raised?
As I said, I was not present when the proposals were being made. I had just wondered why it is that this is being brought as a specific provision under this legislation when the possession of high caliber weapons or high caliber ammunition is already adequately dealt with under the Firearms Act. Firearms offenses can be joined with gang offenses. They can be tried together. And I'm wondering if you include it as an aggravating factor in sentencing, if you're not sentencing the person twice. Let me give an example. So you have a gang case in which you have a firearms offense. They use high caliber weapons. So you have them participate in a criminal organization. You have them charged for illegal possession of firearm. And maybe you have them charged under Section 25(1), which is making use of a firearm to commit a felony, or Section 25(2), which is making use of firearm to commit a scheduled offense. 25(1) or 25(2) carry mandatory minimum sentences. Already, if they are convicted, are you going to find out as an aggravating factor for under the gang thing if everything is tried together? It's another aggravating factor which will carry another sentence. When the person be sentenced twice for basically doing the same thing. I don't know. I'm just throwing it out there.
In terms of use by gang members, because a lot of these weapons, I mean, I know there's a very decided concern about the introduction of assault rifles, some of which are even, specialized weapons that are confined even in more liberal states to the Marine. I know there was some Marine assault rifles were identified in a particular area in Jamaica. And the police was concerned that they're not, even in the current Firearms Act, defining them separately. Or that's not the word I want, but they're nothing there to guide the judge or the prosecutors in making a special case against such people.
Contrary, Chairman, my recollection of the policy rationale for mandatory minimum sentence was that the state viewed the conduct so egregious that in spite of the circumstances, however, whatever the word is, I mean, it escapes me now, that once you are convicted, there is a minimum penalty because of how serious it is. I do, subject to the accuracy of what you've said.
In the existing law, I mean, I'd be advised, or in the law to come, because the FLA has just been revised, and I'm expected to bring it
So,
here
Chairman, if the offense committed alleged to have been committed by the gang or a member of the gang is a firearm offense, it would be natural for that offense to be charged under the Firearms Act in addition to the anti-gang offenses. And in such a case, the person would be liable to be penalized on conviction for that offense. So to cause it to be an aggravating factor, it would only be because of consecutive and concurrency. I think that may be the only circumstance, but it would appear to be an overkill if a mandatory minimum penalty already applies there, because that and it's what, 15 years? 15 years. It would be higher than the 10. Yes, it would be an overkill.
The possession simpliciter, if it's a possession simpliciter case that the person actually is apprehended with the firearm, already it is an aggravating factor in sentencing the type of firearm that is used. So it's already, if it's one that is not supposed to be here, it's not one that ordinary people would carry for their own personal safety and protection. The courts already take that into consideration when they are going to be sentencing. So the assault rifles and the kind of ammunition is already a factor courts take into consideration when they are sentencing.
But an offense is committed with the firearm. What possession would not carry any particular? It has to be an offense conducted using that firearm.
Simpliciter is an offense by itself, and in fact that is the foundation offense to ground
It's a
jurisdiction in the
foundation
gun
offense
court.
for every firearms
every
offense
firearm
tried in the gun
offense.
court.
Yes.
Illegal possession of firearm, and then you have the collateral offenses, shooting with intent, wounding with intent, and so on.
May I suggest that we word this, that on further deliberation of this recommendation, the committee considered whether it was necessary to include this recommendation as an aggravating factor, since the matter is addressed under the Firearms Act, and the law allows for joinder of offenses between those under the Firearms Act and those under this Act. I think that's the best way we can put it to open
we'll
back the discussion. So this reflects what has been discussed up to that point, and the addition would reflect this part of the discussion.
The sentence you referred to, 10 and 15 years, would be the optimum sentence. There are no minimum sentences at this point in time.
Have mandatory minimum under the Firearms Act.
The Firearms Act.
Yeah.
And I mean, I've been,
Yes.
you know, I've never briefed on a new act, but I know that these are something that members of the force have been asking for, because I know there have been a few cases recently in which cases, well, the individuals were not prosecuted on the anti-gang act, other members of gangs. They're prosecuted on the Firearms Act, and they got off with some very light sentences, which pretty much not only upset the investigating officers, but in one case it posed a threat to the individual.
A right of appeal,
the
then, Mr. Chairman, to the Crown to be able to address unduly lenient sentences in those circumstances. A right of appeal for the prosecution.
Right
Mr. Taylor, it is coming as day follows night.
The right of the Crown to appeal, and that exists now in law.
It's coming,
Not,
it's coming, it's coming. It is coming.
It is coming, because
very soon.
That is why I was discussing it. It was, and I know of at least one case that it did provide a challenge, not only in terms of some level of discomfort with the prosecuting, with the investigating officer, but I think the information came from source was fairly easily identified as the person who got off. But you know, it was almost.
We can positively tell the DPP that it is coming, regardless of any hue and cry that may also accompany it.
Time is coming, but I'm going to try and get to the end of the part 3, which is just a paragraph down. Unless we have a long discussion on this, right? 14.2, I know Senator has to go. AG, you want to just finish up for me so we can. All right, Senator, you want to finish that?
Right, 14.2.
Mm-hmm.
A person who contravenes subsection 1 commits an offense. Your committee notes there were no proposals for section 14.2.
15 offenses.
Why is it highlighted, please?
Yes.
I see. All right, then we can proceed.
15.2. 15 minutes finishing.
Section 15. Offenses and penalties. Penalties, second schedule. Section 15.1. The offense described in the first column of the second schedule shall, in respect of the section specified in the second column, incur the penalties set out in relation thereto in the third column. Your committee notes the proposal from MOCA regarding an offense of using property, inclusive of real property, for purpose which constituted an offense under the Act. Section 15 is related to the schedule, which consists of all the offense-creating sections and the applicable penalties. Your committee accepts the recommendation and notes the need to create an offense for using any premises in furtherance of gang activity, similar to what obtains in the Law Reform Fraudulent Transactions Special Provisions Act. Section 15.2. If an offense under Section 4 is committed by a person on the premises or grounds of or within 300 meters of a school or any other educational institution, the person shall be liable to such additional penalty as may be specified in relation thereto in the second column of the second schedule. Your committee recommends that subsection 15.2 be expanded to address aggravating factors, especially in relation to schools. Your committee agreed that section 15.2 should be expanded to include reference to the other offenses under the Act, in respect of which the committee agreed that aggravating factors are to be applied when sentencing a person convicted of any such offense. Section 16, offenses committed overseas. Your committee notes there were no proposals for section 16.
Thank you, Senator. We're going to adjourn at this point. I want to thank Senator and the AG and Mr. Golding left earlier. And special thanks to the technical officers who are here, the professional office team. It is the responsibility of Parliament to get this thing done quickly. We have been going for almost a year, a full year. So I'm going to urge the Secretary is going to see to get a Wednesday and a Thursday on the current schedule despite of the other committees. I would love to see it next week. I might be off next week. Yeah, but I may have to, I'll brief you out of the meeting, but I may have to be out next Wednesday. And a quick trip Wednesday, Thursday. So the following Wednesday, Thursday. And I've asked to pursue not just the committee vacancy, but if possible, if we have to get a room at the conference center, we do it. It is important to finish this. And when you have got the dates, Madam, please inform me. I will call the members, the parliamentary members myself. Eh? No, the 31st. Something emerging from, I'll talk to you. All right. A week. Put 4, I will do it the following week. Give me the dates you're available, AG, because you're critical. Yeah, give me those November dates you have when you're here. Give me a Wednesday and Thursday. Okay, Karen, say. On the other committee, we are trying to steal 2 days from PAC and the other committee, just for.
Sir, we had a 14th.
The 14th? We have November 14th and 15th.
No, it's not.
We are blocking those. Blocking those 2 days.
I'm going to see if I can get the 13th.
All right. 13th and 14th.
I'm going to try.
We're going for the 13th and 14th. That's not a week you're off.
Housekeeping matters before you go. I see a proposed search and seizure provision for the JCF that was circulated. Is it to be disregarded?
For okay. No, not disregarded. Put back in the sphere. It's when we come back on this committee.
Okay.
All right. All right, again, thank you all for the patience. And as I said, I will take a personal interest in getting the parliamentary members to be here for the next 2 meetings. Once the data is settled, I'll call them from my office as well as the usual emails going out. I think we are wrapping up now. We need not only parliamentary teams to be here, but we keep in tune with our professionals. No, I would certainly, Mr. Richards made note to get the data required on which of them?
The amendments from CBC.
Oh, your comments on the recommended amendments to get them circulated early, Mr. Foster. Mr. Richards. Right. They were what we discussed earlier. Make sure we get them circulated on time. All right, thank you much. Sound like we're having a storm outside anyway. See, hope we get home safely.
United Nations Day highlights the enduring ideals of the Charter adopted on this date 74 years ago. Amid stormy global seas, the Charter